Okay, thank you. Just before I draw it to a close, can I just ask a question myself, directed at Mr. Auer, which picks up in a way from what you were just discussing. But if I can go back to what you said at the beginning in terms of this legislation, in your view, being based on bad assumptions, if I can put it like that, this is, that this is about the reason for the success of these firms is because they've been anti-competitive as opposed to actually offering a good product, and that the cases that have been brought have not succeeded because the cases haven't been good cases, and the various firms have succeeded in your view, proving the merits of what it is that they are doing or offering. If that's your view, I suppose my two questions are, one is then, why is competition legislation of the kind that we are examining here being introduced in all of the jurisdictions in sort of all parts of the Western world? And if the problem that this legislation is existing to solve is not what you think it is, do you think there should be no legislation? Or is this a different problem, and you think we've just misunderstood the problem? And I've got Chairman's prerogative in terms of final question here, but please.
So why the pushback? I think it's always been the case that there's been regulatory pushback against new technologies. You get new firms that emerge, their founders become very, very rich, and I guess it's frightening to people. I would also add that regulators are not sort of acting in isolation here. They are, exchanging ideas in part at the ICN, for example. So that's one thing. And the second question you mentioned. I'm sorry. I'm.
Well, what I'm struggling with is if you think this is based on bad assumption, and the legislation is being introduced in different jurisdictions in any case, is there another problem that you think needs to be the motivating factor underpinning this legislation, or do you just think there should not be this kind of approach to antitrust issues? I can see all my colleagues jumping up around me.
I'll answer very shortly. I think that whether or not there is regulation is much less important than if there is regulation, it should be evidence-based regulation that has baked into it feedback loops that enable courts to review what the regulator is doing. I think that's the most important. And at the end of the day, I'm personally agnostic between competition law and digital markets regulation. I'm not agnostic about having good judicial review.
Your main concern is around the process of JR or a merits-based appeal.
I think that's the biggest issue. It's not the only issue. It's also about the bill trying to write a bill that is in quantifiable terms, that has rules that are more explicit, more limiting principles written into the rules. Okay.